she's so fine. Hell of her blows my mind. Hell of her lights my day.
What's good, guys? This video, as you can tell, will be regarding the Kenneka Jenkins case, and specifically it will be regarding the lawsuit that was filed by Tereasa Martin, who is Kenneka Jenkins' mother, against Capital Security Investigations, Crowne Plaza Chicago O'Hare, doing business as F&F Realty, NBC Rosemont, doing business as Murray Brothers Caddyshack, and CPO Hospitality. Now, she filed that lawsuit on December the 11th of 2018. Case number 2018 L013273. And I have spoke at great length about this lawsuit. And recently, there was a settlement that was agreed upon by all parties. And what a lot of people are either one side far on the right or one side far on the left. Happy that they reached a settlement and that Miss Tereasa Martin is going to get some kind of monetary award out of this case. And the other side is upset that she agreed to the settlement. And what's particularly been a big topic of discussion in regards to this case is that a settlement was actually reached. Now, originally, Ms. Tereasa Martin had sued those parties for the wrongful death of Kenneka Jenkins at the Crowne Plaza Chicago O'Hare in Rosemont, Illinois, September the 10th, 2017. And she sued them for $50 million. Now, what is up for debate and a big topic of discussion is that Miss Tereasa Martin, as well as all parties involved, want this settlement agreement to be sealed by the court. And that is what seems to be the controversy surrounding this situation. Now, they do have a court hearing. They had a court hearing today. It was denied. They have another court hearing on the 16th at 9 o'clock a.m., also at 10 o'clock a.m., in two separate courtrooms, because they are wanting the judge to agree to seal this settlement agreement because they do not want the public to know. And I wanted to talk a little bit about the why behind this and what the actual law says about this. What I particularly wanted to know was not necessarily what she was awarded monetarily, but I wanted to know which of these parties, because it mentions that two parties paid this settlement. And I was interested to find out which two of these parties that were the defendants in this case paid the settlement agreement. In other words, which two parties were held legally responsible for the death of Kenneka Jenkins? That was what I specifically wanted to know. Now, she reached a settlement. I guess it's been a little over a week now. But as most of us feel, I can't say we can prove, but as most of us feel, there was some foul play in the case of Kenneka Jenkins. There's a lot of unanswered questions specifically in regards to the case. And I wanted to go over just a few little things in regards to this settlement. Now, as we know from this channel and several other channels that have covered the court filing, this case has had its spurts from December of 2018 going forward. And one particular spurt really started in August of this year. And on the 14th of August, a Rule 707 statement was filed by Matthew Ross. And what that essentially says is it permits an eligible out-of-state attorney to appear in an Illinois court proceeding without having to be admitted to practice law in the state of Illinois. And it's a very simple, they submit this statement saying their name, their address, and where they currently practice law. They attach a letter of good standing from their jurisdiction, and it's just very simple, and they mail it to all parties in a particular case. They did that in the Kenneka Jenkins case on August the 14th. Then on September the 14th, there was a motion filed, an unopposed motion for leave to file petition for settlement and distribution under seal. This is where they started talking about wanting to seal this court document. On the 18th of September, notice of motion was filed. In other words, putting everyone on notice that this had been filed. On September the 26th, there was an amendment filed in regards to the pleadings, and it was allowed. Also on the 26th, the case was continued. Apparently negotiations were still taking place. It went on up until the 11th of October, which is today, and they have a status of settlement. They were supposed to be in court today. And they also go back on the 16th of October for the judge to make a ruling as to whether this case is to be sealed so that no one can be able to access the information contained in that file. Now, do I agree with that? A lot of times you'll see this in a high-profile case where this is often requested. Is Kenneka Jenkins a high-profile case? It was covered as a high-profile case, so I understand it. But I'm going to tell you what the court says about these. So when the parties asked the judge to seal this, they presented him with an agreed settlement order with a status date on it. And down in the body of the actual settlement order that the judge signs off on, he checked no, that he did not want this sealing, and he denied it. And what he also did was he set it for a status hearing. That status hearing was today on October the 11th. He could also check the box that says this case is set for trial. He can hold an actual trial to decide whether or not to seal the documents of this particular litigation. Now, there is several things to understand. Although the state of Illinois does not have a statute or Supreme Court rule setting particular guidelines for sealing court documents and files, the actual courts have authority to seal certain documents or entire case files as part of their inherent power to control their court records. It is important that a trial court be permitted to shield sensitive information from public view. However, as stated by one court, judicial proceedings are not closed whenever the details are titillating and open only when the facts are so boring that no one other than the parties care about them. Now, in civil litigation, which is what we have here, information that can be kept confidential includes trade secrets. We're not dealing with that here. Privileged information, which is attorney-client privileged information. I do not believe we're dealing with that here. And information required by statute to be maintained in confidence. For example, the name of a minor victim for an SA. Nonetheless, once pleadings, motions, and other papers are filed with the court, the presumption of public access attaches. Now, the Supreme Court of the United States says a trial is a public event. What transpires in the courtroom is public property. There is no special prerequisite of the judiciary, which enables it, as distinguished from other institutions of democratic government, to suppress, edit, or censor events which transpire in proceedings before it. A lot of times you will see challenges to sealed court files coming from newspapers and the media because they want to have access to that file so that they can report on it. When courts are open, their work is observed and understood, and understanding leads to respect. The file of a court case is a public record to which the people and the press have a right of access. Any step that withdraws an element of the judicial process from public view makes the ensuing decision look like something's wrong, guys. So, the public has a right to access documents or a class of documents. You can walk into the courthouse of your given area, jurisdiction, and ask them to see a case file. A lot of times there's a record room. You can walk right in there if you know how to operate a record room, and you can go right in there and pull your own file. You'll probably have to pay for your copies, but you can do it. They might get aggravated at you. Typically, I'm not saying this is every place, but where I'm at, the state employees that work in the courthouses, specifically in the record rooms, are not very friendly people. And they get kind of irritated when asked to do something. But nonetheless, you have access to those. You can go and get a copy of it, pay for your copy, or you can take notes from it. You can do whatever you want to do. But when you talk about sealing a court file, it really, a lot of judges do not like to do that. I'm just going to be real honest about that. Now, I understand because Miss Tereasa Martin lives in Chicago. She is concerned about her safety and her privacy. And there may be things that she said that she didn't want out, or facts of this case that she doesn't want out. And maybe that's why she wants it to be sealed. The other parties would obviously want it sealed because they wouldn't want someone to be able to say, oh, well, you paid X amount of dollars to this person for a wrongful death, and be able to compare those numbers to maybe a case that they have against those people. It also makes them look like they are easy for offering a settlement in a particular case. It makes them look guilty for offering a settlement in a case. So there's a lot of reasons why people would want the court files sealed. Another reason for question in regards to a wrongful death suit is, and I learned this in my Issues in Ethics and Criminal Justice class, which I always say is an oxymoron because to me there are no ethics within the criminal justice system. However, in the 70s, Ford Motor Company made a small little car that we know as the Pinto. Most everybody knows what that car is. Smokey on Friday drove one. Over time, it became apparent to Ford Motor Company that the Pinto had some serious defects, which caused the car's fuel tank to rupture and explode because it was located on the rear of the vehicle. This often caused fiery deaths and severe burns to victims. Ford Motor Company, as you can imagine, was subject to many wrongful death lawsuits from exploding Pintos. But they paid the ones they lost at trial. What made the Pinto a particularly notable case was that Ford had actually done a cost-benefit calculation on this exploding Pintos, where it would only cost $11 per car to fix that defect. However, Ford Motor Company decided that it was cheaper for them to continue to pay wrongful death and personal injury verdicts than to recall all those Pintos and pay the $11 per car to fix the defect. Now, Ford was smashed with punitive damages awards in an attempt to send a clear message to the manufacturer. There was one specific case in notable, which was Grimshaw versus Ford. In that case, 1972, the car was hit in the rear at 30 miles per hour. A person named Lily Gray was killed, and a 13-year-old was horribly burned because the car exploded. The jury awarded the Gray family $560,000, and the family of the 13-year-old, the Grimshaw family, $2.5 million in compensatory damages. The jury, however, sent a message to Ford with a $125 million punitive damage award. And what the problem was that Ford had done this cost-benefit analysis, $11 to fix the defect, but they actually put a value on human life where they were willing to pay these wrongful death suits. So what is a human life worth monetarily? And that's where we get into trouble as far as ethics goes. But then you also have high-profile cases. For example, the O.J. Simpson case. The first person to walk on the moon, man to walk on the moon, Neil Armstrong. Those two cases were very public in their settlement amounts. But there are also high-profile cases, just like Aaliyah. And her agreement to settle was never made public. So that's just something to think about. Specifically in the state of Illinois, all records in the custody or possession of a public body are presumed to be open to inspection or copying. Any public body that asserts that a record is exempt from disclosure has the burden of proving by clear and convincing evidence that it is exempt. That includes all legislative, executive, administrative, or advisory bodies of the state universities, colleges, counties, townships, cities, villages, incorporated towns, school districts, municipal corporations, boards, bureaus, committees, or commissions of this state. That covers the courts. So it's going to be very interesting to see what the judge is going to do in this case. I'm not really sure. It could really go either way. I would say a federal judge more than likely would deny this request to keep the documents sealed. A judge in Illinois, and we know that Illinois is full of a lot of corrupt governmental people. It's just facts, guys. I don't know how it's going to go. I will be very interested to learn that. But I just wanted you guys to understand the law in regards to public records and understand what has happened in this case. The judge may take a sympathetic side of Miss Tereasa Martin, more particularly, because she does live in the city of Chicago. I don't know. I guess we will be finding out very soon. I would say around the 16th of October. So I'm going to end this video on that note. But if you have any questions, feel free to ask me. I don't mind answering anything. I try not to insert my opinion in this. But like I said, I would really like to see who was held liable in the wrongful death lawsuit of Kenneka Jenkins. Thanks for watching, guys. Have a great night.